next case is John Gray versus Ann Gray. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims in your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Good morning, Your Honors. May it please the Court. Matthew Avery on behalf of appellant Dr. John Gray. I'd like to reserve 4 minutes.
You may proceed.
Thank you, Your Honor. Your Honor, I'm here today on behalf of Dr. John Gray, and essentially we want to argue 3 points. First, that the trial court abused its discretion by not finding that Dr. Gray had presented the evidence to reach the standard of impossibility as outlined in Reisinger versus Reisinger. Secondly, that should he have been found in contempt, the purge conditions are both unreasonable and impossible for him to comply with. And finally, that under those same arguments of, in the first 2 premises, that the attorney's fees are inappropriate based on the evidence found at trial. Your Honor, these parties were divorced in 2004. Dr. John Gray at the time owned a budding medical practice and was making a salary of $200,000 a year. And throughout the course of this, he paid his support timely until around 2009, when he was in my opinion, a victim of the opioid crisis. He was falsely accused and sued by a medical mutual, and he essentially had his practice poisoned. Without him there, the property settlement and their separation agreement that allocated the valuation of his medical practice at $1.2 million became essentially valueless. At the time, he had paid, in 2010, the magistrate's decision outlined that he had paid over $330,000 of his property settlement, of which he originally owed $640-ish thousand. He also had completely paid his spousal support obligation and his child support obligation. That obligation also included that there would be 13 years of this property settlement payment, which would take them both to the age of around 65. So in my opinion, it is presumed that they are intending to do this until the age of retirement. But 6 years later, he is a valueless business and he is unable to continue doing so. So in 2010, the civil case wrapped up in the opioid crisis, and Dr. John Gray was able to essentially attempt to get his credentials back. Medical Mutual decided for 7 years to reject his credentials. And so he didn't receive credentials to treat any Medical Mutual patients until 2018, making him virtually unhireable. He attempted to work around this by going to fringe clinics that were either on the edge of the state or all the way down in Cincinnati, and he continued to do so until around 2018, 2019, when his health took a downturn. So as of 2020, he was diagnosed with acute heart, He was diagnosed with a heart condition. He has tremors in his hands. He has generalized anxiety disorders, and all of these can be found in the transcript, making it virtually impossible for him to continue, and ultimately his medical license lapsed in 2022.
Counsel,
yes.
Go back to the allegations from Medical Mutual.
Yes.
Was there any evidence in the record that your client filed a lawsuit or looked into filing a lawsuit in regard to all that?
Your Honor, no, there's no evidence that he countersued at that time.
Isn't the issue, though, that it's a property settlement, not a spousal support?
Yes.
And the other issue is the magistrate found, or the judge found, that he had the money before now to be able to pay now?
Your Honor, it is a property settlement issue, but I believe that based on how the spousal support, child support was calculated and the duration of those, they limited those to kind of incorporate that. The property settlement was in lieu of a spousal support obligation, although not expressly written into their separation agreement. I believe that would be the contemplation that a reasonable mind would have to infer.
So if we find this is an abuse of discretion, doesn't that set a precedent that you just don't pay settlement of money owed, and then when you're finally retired or disabled, it's abuse of discretion to find someone in contempt?
I believe that it's oversimplification of the conditions that he is facing. Essentially, if you have a $1.2 million IRA that you were designed to split in a separation agreement, the market crashes and it goes to zero. Am I required to divide it in half at the point where it was there, or do I have to wait for the market to rebound? He has an asset that's $1.2 million and now it's worth nothing. So how is he supposed to continue dividing that asset when the value goes to zero? It wasn't from an intentional use to diminish the value of the asset or to rearrange the spousal support obligations or anything along those lines. It was through no fault of his own that the situation created an impossibility based on external factors.
But counsel, I think Judge Lancaster is referring to the fact that instead of paying what amount he did have, he went out and paid cash for a house.
Yes.
And didn't contact the court to try to, to vacate any of this prior settlement.
I believe that it would be significantly past the point of being able to vacate, but he also can't modify a property settlement. So
Well,
the
regardless,
only,
the point is he just elected not to pay.
so he has his IRA that he cashed out, which was a divided marital asset, but even if he had paid the full amount of his IRA to her, he would still be in this exact situation because it doesn't reach nearly the sum total that's required by it.
Well, but it might just warrant a possibility. If you had taken that $100,000 and the $140 in the bank and paid that to her and then said, I don't have anything, I can't pay, well, now we're talking a possibility. But when you have $100,000 and another $140 and you pay none of that to spousal support, it's kind of hard to say it's impossible if you make these payments. He could have done something.
And I understand that he could have done something, it's just where do I draw the line on how desolate he has to be before he can do anything. So he remarried and has a 14-year-old child
Does
that
he own
was.
a house outright though?
No, he does not. It is in an irrevocable trust.
And he transferred it into the revocable trust.
Irrevocable, yes.
They pay cash for it.
Yes, Your Honor. And so at this point, he is a 72-year-old man with significant health conditions. If any attorney recommended that he didn't have an irrevocable trust to put that house for Medicaid planning in, I would be astounded. But he did put it in to an irrevocable trust after paying cash for it, yes.
And if he made any payment on spousal support, he'd get $3,000 a month of Social Security. He said, here's $500, here's $1,000, here's all I can afford. Has he done any of that?
He did for a period of time, but at this point.
What period of time?
Until 2020, he was still making some payments.
So he stopped after 2020 making.
When his health completely declined, and I think that the vast majority of the money goes towards his medical bills at this point.
Was there testimony to that?
Yes, he testified about all of his medical conditions.
But that all
in the
of his money
transcript.
goes toward his medical bills?
Not explicitly, no, Your Honor.
That's what I was wondering. And then the second thing is in regard to that, was 2020 whenever he started receiving Social Security?
Yes, I believe so.
So what expenses did he indicate that he had to demonstrate that with $3,300 coming in each month and no house payment, that he couldn't pay anything?
I don't believe that there was any testimony provided at trial that specifically stated as to why he was not paying a portion of the Social Security disability other than the need as that's the only income for the household.
It sounds like you're saying he had problems with his medical license, but he kept his medical license through all of this?
Yes, Your Honor. So
So he was able to work as a doctor somewhere in Ohio?
So not entirely. So his medical license was suspended for a period of time while the medical mutual was pending. Upon its finalization of him being not held at fault, medical mutual refused to re-credential him, which made him unhireable for the vast majority of the Ohio clinics. He did find some clinics that were in Cincinnati or at the edge of West Virginia that tolerated him being unable to do this, but even at that point, he was making a significantly lower portion than what he had made before, and had no property left to divide. And speaking to this, Your Honor, I think it goes to the next point for, should he have been found in contempt, the purge condition of forcing him to pay $20,000 is now something that can be becomes unreasonable. At this time, he doesn't have that complete ownership of that home. It's in the irrevocable trust, which unless we decided somehow that we could void that irrevocable trust, or there's some pending litigation in a court to do so, he doesn't have full uninhibited access to obtain funds out of the home. And should they do so, then they wouldn't be able to afford the home anyways, creating
So it's a revocable trust where he is the trustee?
it's an irrevocable trust where they are co-trustees.
I see, okay.
Yes, so he would need to be able to pull that out and convince another party who's not a party in this matter. So I don't believe that the $20,000, considering there's $5,000 in his checking account at any given time going forward, and his total salary of from Social Security income is less than $30,000. I don't think that a $20,000 base payment and then a loose term of figure out how to pay the rest is an appropriate purge condition for this matter. And then finally, the attorney's fees, should he not be held in contempt of attorney's fees, would be wholly inappropriate in the matter if we're able to come to the conclusion that he should not have been held in contempt by reason of impossibility.
Counsel, was there any evidence, other than the fact that he said it was an irrevocable trust, was there any evidence about the terms of that trust that was presented in evidence?
I don't believe that the terms of the trust were admitted into evidence, but generally speaking, the terms of the trust that he had testified to were that he was not the sole trustee of the irrevocable trust.
And you're about 15 seconds away from being in rebuttal.
Thank you, Your Honor. I'll rest at this time.
You may proceed.
Good morning, Your Honors. Thank you. Wayne Nickel, on behalf of the appellee, or appellee, I never know how to pronounce that, but Ann Gray, who's here today with me. She traveled up from Cincinnati to be here, to be present for her hearing. I want to just respond to some of the things that Attorney Abrick brought up, clear up some things regarding the record. But I just want the court, I think this case, and I think some of the questions kind of sorted that out. This case is about choices. Dr. Gray made a number of choices throughout that led Ann Gray to file a motion to show cause. There was prior litigation regarding his efforts to vacate this property division prior to this case even being initiated. That motion was withdrawn without prejudice, and then that was attempted again to vacate. So there was additional litigation after Ann filed her motion to show cause, seeking to vacate that property division with the very same arguments you've heard this morning in appellant's brief, seeking that to have it set aside or vacated because of the idea that it was somehow impossible to fulfill the terms of that property.
But counsel, this was within this most recent litigation?
That's correct.
Was there anything filed like in 2020 when all this was going on with his private practice or anything?
There was, at the time, Your Honor, there was also a motion to show cause that was filed, and those motions were resolved. The motion to vacate was, I believe, withdrawn without prejudice, and then the prior show cause was resolved, required Dr. Gray to make payments, which he didn't do, which brought Ms. Gray to the current show cause that was filed. And the timeline is important because her motion was filed in 2022, which now we're 3 years later in the Court of Appeals, but the idea that Dr. Gray's employment circumstances made it impossible for him to comply. I agree 100% that there is a huge distinction between a property division, which is what we're dealing with, and a spousal support board. At the time of the divorce, these parties were married for 27 years. Dr. Gray was a physician earning, I believe the record indicated, about $200,000 a year. And the spousal support award for my client, who was traditionally a homemaker, did have some employment throughout the marriage, but it was $3,000 a month for 36 months. And I don't disagree that Dr. Gray fulfilled that, but as someone who's been doing domestic relations for 2 decades, for a 27-year marriage, for there to be a 3-year spousal support award, there was something else in that agreement that warranted that consideration. And I agree with counsel, that agreement was this property division, which my client, the benefit to her was that it was not tax deductible. At the time, spousal support was tax deductible. And so they made this agreement for this property division. And Dr. Gray did pay for a period of time, but then he stopped paying. He made the decision, the choice, to stop paying, or initially made the choice to reduce the amount. He chose to reduce the amount to an amount, and then ultimately decided, I'm just not going to pay anymore. And I think that those decisions weighed heavily on the magistrate and his decision to find Dr. Gray in contempt. There's no question he was in contempt. There was a valid court order, he violated it by his own admission. So that problem of finding for contempt was met. There's no dispute in that. But he didn't.
Well, the question would be, is the defense impossibility met? Certainly he didn't make the payments he was required to, and they're not disputing that. They're
Right.
saying it was impossible because all my money now is tied up in this irrevocable trust and I can't pay anymore.
Right, and the timing of that, Your Honor, I think is important. The timing of, the magistrate found in as early as 2021, he had access to an IRA that he liquidated, over $100,000. He used none of that to satisfy his financial obligation to his ex-wife. Instead, he remarries someone very much younger than him, who has a child that he, at the time, before he married her, had no legal obligation to support this young child. But now he comes to court and says, I don't have any money, I'm married, I have a child that I'm now responsible for, I can't fulfill my obligations on an order that I agreed to 20 years ago. So I think the magistrate found and was able to observe the demeanor of the witnesses during the hearing to find that those reasons were not enough to sustain impossibility.
Right, do you think, because this isn't spousal support, because it isn't child support with a property interest, it's not about ability to pay? I mean, she could have gone to trial, right, and got the half of her fair market value of this property at the time, and that could have been a judgment, but instead she agreed. So do you think the standard of I can now not pay, or don't have the ability to pay, is even relevant here?
I don't, Your Honor. I think there's a situation that, because the cases cited are spousal support cases, this is property division. There's nothing in the record that this business was valued at $1.2 million. You can look at this divorce, look at the divorce decree, and you will not see anything about the business being 1.2. You can make the assumption, I suppose, that if someone's to pay $600,000 for a interest in property, that maybe the property was worth 1.2, but that's not in the record. So I agree with you that she could have went to trial and the spousal support work may have been more, but she nevertheless agreed to this property division, and here we are.
For example, I just want to put it this way, if if they weren't married and they owned a home together and it was split, she would have the remedy of going to civil court, and that judgment wouldn't be excused. But what remedy what other remedy does she have here to recover her property interest?
Well, and that's a great question, because now we have a house that if the property division if the court found, which they did, that he owes her $200,000 or whatever the amount was, $200,000 plus. At that point, she could ask the court to ultimately reduce that to a judgment, and that judgment could then be filed as a lien against property that he owns. However, while this case was pending, not years ago when he married his now wife, he put this property that's $300,000 plus value into a trust while the case was pending, after the motion to show cause was filed against him in 2022. So she's not going to have a remedy of that part, of reducing it to judgment and then filing a lien. So she's at a disadvantage in that regard, where most judgments that are reduced, you can do that. In this case, it's in a trust, so it's probably not attachable. That's beyond my pay grade. I only do domestic relations. I would probably refer her out to take that next step after we get through this appellate process, assuming we're victorious. But again, those decisions were made by Dr. Gray to liquidate his IRA, to have a home that's owned free and clear, to put that home into a trust. All these things happened either right before this case was filed or during.
Counsel, I am still confused over something, so I want to go back.
Sure.
I'm sorry, to make sure I understand. This was the second contempt that was filed against him?
Second contempt, first one that I represented her on, the first one, the initial contempt was filed 10 years ago.
Okay, and that was for not paying the property division?
Same issues, yes.
Okay, was that settled?
It was settled.
Okay, and so what were the terms of the settlement?
That he was to continue to pay the sum of $4,000 per month that was already ordered. So just a reiteration of the order that he already agreed to. And there was some legal fees in addition to that that he was to pay. I'm not certain if he fulfilled that, honestly, in my representation of Ann. I don't know that I ever asked that question, that whether those legal fees were paid. But certainly didn't fulfill the terms of the new agreement.
Well, and that's what I wanted to make sure about. Which contempt are we talking about? Which agreement are we talking about here now? Are we talking about the original divorce decree, or are we talking about the settlement agreement from the original contempt?
The settlement agreement that was reached did not modify at all the original terms of the divorce decree. So we're talking about the divorce decree. There was a stipulation of the amount that was owed for the property settlement. It's in the record, $248,400 was the stipulated amount that was owed to my client, as the remaining amount of the property division. Does that answer your question, Your Honor?
Well, I just want to make sure we're comparing apples to apples.
Yeah.
I mean, because if there was obviously a settlement agreement, then the contempt should have been on the settlement agreement and not on the original decree. So it may be irrelevant by the fact that it was all the same. Is all that going to be in the record?
Yeah, that's all in the record. The settlement agreement's in the record. It's part of the docket.
Okay.
And again, that settlement agreement did not change the terms of what Dr. Gray owed my client.
So this was not reduced to judgment, right?
Never.
The reason I'm asking is because obviously you can't fraudulently convey something to avoid your creditors, but does the spouse, the other party, in a decree constitute a creditor? I'm just trying to make sure I understand all the points here they're working on.
Sure, thank you. With regard to the purge condition being unreasonable, again, we have an amount of money of over $200,000. The purge amount was $20,000, which is 10% of the total, less than 10% of the total amount owed. The legal fees that my client had incurred at the time was $4,200. That was not unreasonable given all of the litigation that had occurred up until then. And I'll note, Dr. Gray paid double legal fees to fight the contempt, which every person has a right for counsel for a contempt. I'm not disputing that. And the firm that he represented is well-known and reputable, and they do a great job. But it's interesting that he's saying it's unreasonable for $4,200 in legal fees, half of what I paid at the time. That's an unreasonable amount of legal fees. But the testimony in the record indicates that at the time, again, we're back in the contested hearing in February of '24, he had paid $10,000 already at that point. I will note my client has incurred additional legal fees. She had to incur additional fees to fight an objections hearing, to fight now the Court of Appeals, which again, that's the process that we have, but she's additionally incurring legal fees. Dr. Gray is able to pay his legal fees of $10,000, but is saying I don't have any money to at least partially satisfy the property division to my ex-wife. Again, a choice that he's made, which is the theme throughout. Looks like I'm maybe up on time.
3 minutes.
Oh, 3 minutes, okay, great. I just want to point out, with regard to the medical mutual, again, I don't think it's relevant because it goes to spousal support and why he couldn't earn a living. He did have assets, which the magistrate found that he decided not to use to satisfy his obligations to his ex-wife. That's right in the record. The magistrate was clear as to what he had. In fact, the year, I believe it was 2021, his tax return, which was admitted into evidence, Dr. Gray made $180,000 in 2021. That's in my brief. But yeah, gross income in 2021 of $183,000. So I just asked the court to take everything into consideration, all the arguments in my brief, affirm the judgment of the trial court, finding Dr. Gray in contempt, ordering the purge amount as well as the legal fees that were ordered. Thank you very much.
You'll have 4 minutes and 11 seconds on rebuttal.
Thank you, Your Honor. First, I'd like to address that I think that what we've come to understand just from counsel's testimony today and representations today, that these parties conflated the difference between property settlement and spousal support so that they would have the highest economic gain for.
But they did
Ellie.
that. That's the choice they made back in whenever they separated. That's the decree we have now. He has to abide by
It
it.
is 100%.
Or move to vacate.
Yes, Your Honor, I understand.
So I don't dispute that they seem to have played some games in what they were calling property and spousal support
Yes,
in the
Your Honor.
agreement. But how did that affect our decision to say, did you follow the order?
And I don't believe that it was contemplated that this was a possibility at the time, that he could have lost his entire practice.
I suspect it wasn't, but again,
Yes, Your Honor.
that's unfortunate. They could have put something in there to protect that, and they did not.
Yes, Your Honor.
And the good choice he made to not be paying spousal support is more.
And I completely understand, but.
But my question is, okay, why is it relevant to, did he comply with the order as far as contempt goes?
Yes, Your Honor, if you take a textualist reading and you go through that and you say, this is what it says, they're not gonna look at any of the extrinsic factors, then you can say, nope, that's spousal support, that's property settlement. But now in today's standards with family maintenance, I don't know that this would even be an issue, we would have placed it in a different.
But again,
And
great,
I understand
you're right,
you, Your Honor.
fine,
That's my
but this is
argument,
what
that
we have.
my-
I appreciate you have a defense of impossibility. If
Thank
he
you.
can't pay, he can't pay, and that defense exists. And he has the right to assert it, no matter what, whether it's spousal or child or property division, he has the right to assert his defense that you've done, that it's impossible for him to make the payment.
Yes, Your Honor, and the property settlement was specifically for this medical practice. So the medical practice becoming valueless, should the motion to show cause that occurred in 2010 allocated that he had paid his entire spousal support obligation, paid his entire child support calculation for a total of $479,600. What he retained out of the medical business is what it is. It's going to be.
But that would go to impossibility, I would
Yes.
say, if this
Yes,
is
sir.
no longer worth any money, he can't practice.
Yes, Your Honor, so if she would have pursued.
Council suggested he made $180,000 in 2021, the year this was filed.
Yes, Your Honor.
Was the testimony presented about his medical condition that took place after 2021?
Yes, Your Honor, so 2021 was when health started to decline and his license lapsed in 2022. So he was still doing the fringe practices through 2021, but I think that fluctuated throughout the years depending on how much money he was making and the hours that he was able to get at these clinics, specifically being kind of a visiting physician.
And when you say license lapse, I'm not familiar with the licensing practice. Do you have to apply and ask to have the license go forward, or were there some medical
It's
testing
similar-
that said he lost?
It's similar to your legal license. You have to have your CLEs that are completed, and then you have to do board exams, continuing board exams in the medical field. So should he not be able to do those, and his was lapsed due to his health concerns, that he was unable to continue practicing at the level that would be competent and available to his client.
And I can't remember, was that just his testimony?
Yes, Your Honor.
Okay, so he didn't present any medical evidence of that?
I believe that him as a physician testified on his own behalf for his medical evidence.
Was there any dispute from appellee
Not that I'm aware of, Your Honor.
that he was able to work?
And so at this point, I also want to address the legal fees issue. It was not ever a concern that the legal fees were unreasonable based off of how Attorney Nichols had performed or anything along those lines, hours or anything like that. It was more that he should not be responsible should he not have reached the impossibility standard for those attorney's fees. And just to close.
I'm sorry, I do have one question, factual question.
Mhm.
Do you have any evidence in the record about when this trust was created and how it was funded?
I believe that it was only testimony, and it was a transfer. The only asset in the irrevocable trust is that residence, that they had cashed the IRA out in 2019 for a separate residence, and then upon finding that there was a 14-year-old and an adult-only residence, they were evicted
Okay.
and then purchased this home.
But I'm trying to get to the heart of,
Yes, Your Honor, it was
They did.
after the motion to show cause was filed.
okay.
And so at this point, Your Honor, just based on the relative resources of the party, I would ask that he has reached the level of impossibility in general and then also for the purge conditions and asked that they be amended should he be found in contempt to a reasonable purge condition.
Thank you.
Thank you, Your Honor.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision when it's released, and the opinions are also posted on the Ohio Supreme Court website. Thank you both for your presentations.
Thank you, Your Honor.
Thank you very much, Your Honors. Have a great